Well, my clock says noon, so we're going to go ahead and get started. You might hear a few more people chime in. We do have quite a few people registered for the training today. And I am Heidi Garvin from Grow, Nebraska. So I'm our program services coordinator, and part of my job is to help facilitate trainings like these. So our third Thursday trainings are always free, open to the public, and we are excited to have all of you here. So just a few quick housekeeping things. I did want to update you all on a few projects that Grow Nebraska has been working on. If you are interested in supporting Native American artists in our state, we did just launch GrowNebraskaNative.com, which is helping Native American artists to sell their products and make a sustainable living out of white clay and Pine Ridge. On our BuyNebraska.com site, we have started a new promotion called Free Shipping Fridays. This is going on throughout April. So this is a great opportunity if you want to try some Nebraska products. You can check it out there. We do have free trainings every single month. The third Thursday training is on the third Thursday of every month. And if you want to find out more about upcoming trainings, our next one is going to be on Facebook Business Basics. If you'd like to find out more about these, you can visit grownebraska.org/trainings. If you're interested in trainings and events provided by other organizations, feel free to check out our calendar of events on our website. If you sign up for our newsletter and follow us on social media, you'll also see these events there. After the training, I will be sending all of you an email. So if you have any other business questions or suggestions for training topics, we would highly appreciate it if you email us then. But for now, I am going to introduce our amazing sponsor for the day. We would not be able to provide these trainings for free and keep them open to the public if it wasn't for the support of our amazing sponsors. And today's training is sponsored by the Nebraska Enterprise Fund. So we do have Jane on the line with us. She's going to tell you just a little bit about what they do.
Thank you, Heidi. Like Heidi said, my name is Jane Olson. I work in the Oakland, Nebraska office, but Nebraska Enterprise Fund actually covers the entire state of Nebraska. We offer capital training, mentoring to grow businesses in Nebraska. So we're able to lend directly to businesses that are unable to secure a bank loan, and those loans range from like $1,000 up to $150,000. But we also work with the banks to provide gap financing. So if a business is able to get a loan at the bank, but it just isn't quite enough to meet their business needs, then NEF has loans that they can work with the bank on that. We have ongoing training for our clients, and we offer individual, small group coaching and mentoring. So if you need help starting or growing your Nebraska business, give us a call, and hopefully we can help you.
And we at Grow Nebraska, we absolutely love working with the Nebraska Enterprise Fund, so we highly recommend them.
Thank you.
All right. And so now, the reason we're all here, we have the lovely Susan Sapp with us. She is an attorney for Cline, Williams, Wright, Johnson, and Oldfather. And she is going to talk to us about the most common employment law mistakes made by small employers. So if you have a chance, please do mute your phone so we don't have any background noise. And Susan, I'll let you take it away.
Good morning. Thank you for having me. I appreciate the opportunity to speak with you.
Thank you for being here.
Can you hear me okay?
Yes.
All right. Well, I have been practicing law for 28 years, and much of my work is in the area of employment law, and we work with some of the largest employers in the state, including the university, all the way down to the smallest employers in the state. And so over the years, I've been able to accumulate sort of a checklist of things that I hear most often from small employers that are mistakes or misbeliefs or myths or things that pop up once the NEOC, the Nebraska Equal Opportunity Commission, comes knocking, or the Department of Labor comes knocking, and then folks reach out to me and we try to problem solve after the fact. So I try to put these presentations together to help folks problem solve on the front end before these problems arise. So the most frequent thing I hear is that small employers tend to think that because they're small, the same laws don't apply to them as apply to larger corporations. For example, there are federal and state laws that prohibit discrimination in employment as it relates to protected class status, gender, marital status, pregnancy, disability, age, race, etc. Under state and federal law, this applies to any employer who has at least 15 employees. However, you need to check your local ordinances. City ordinances lower that number in a number of places. For example, you only have to have one employee in Grand Island to be covered by those same employment discrimination laws. You only need to have 4 employees in Lincoln or 6 employees in Omaha. So our city leaders in some locations have decided to lower that threshold to the very, very smallest of employers. So you need to check any city ordinances in your locations that might affect and lower that cutoff for your liability for federal and state law compliance. Americans with Disabilities Act, Title VII, Employment Discrimination, Age Discrimination and Employment Act, Older Workers Benefit Protection Act. Those are all potentially applicable, as well as the Nebraska Equal Employment Protection Act. So related to that then is, once you know that you are most likely covered by most or all of those federal laws, it's important to educate your employees, your supervisors, and your managers what their obligations are under these laws. Anti-harassment is very important to provide training for your employees and your supervisors and your managers. It's the way that you protect yourself against liability for harassment. I think the word harassment is probably one of the most confusing areas of the law for lay people. I get calls probably once a month from somebody who says, well, I'm being harassed at my job. Okay, well, tell me more about that. Well, they're constantly evaluating me and writing me up for mistakes, and I feel really harassed. Well, why are they doing that? Why do you think they're doing that? Well, because they think I'm doing a bad job, and I'm being harassed into doing a better job. Well, that's not illegal. Not all forms of harassment are illegal. You can write somebody up, and you can discipline them, and you can set job expectations, and you can enforce hours, and you can enforce schedules, and you can enforce performance. That's not harassment. Harassment becomes illegal if you're doing those things and holding people accountable and evaluating them differently because of their membership in a protected class, because they're a woman, because they have a disability, because they're a minority, because they're a particular religion. The harassment has to be occurring because of their membership in a protected class. So along those same lines, just because an employee thinks that an employer is being unfair doesn't make it illegal. So you have to teach your managers and your employees and your supervisors how to address illegal conduct and eliminate it in the workplace, as well as educate folks on what is not illegal, so that their expectations are aligned with what the law provides, not their own sense of what is right and wrong or what is fair or what they see on TV. So the most common form of harassment that you've got to do training on is sexual harassment. It can still bite employers. You would think that with all of the news coverage and familiarity with sexual harassment that we just wouldn't be seeing those problems anymore, but we still do. Some of it relates to a lack of training. So it's important to have annual training for your employees and your supervisors. You've got to explain to your supervisors what their responsibility is when they get a report or when they see sexual harassment. Just because somebody says something sexual to another employee doesn't mean it's illegal. It has to be unwelcome. But a lot of folks will get fired for performance reasons and then sort of re-edit history about what happened in their employment. And suddenly there's a sexual harassment complaint, and jokes and whatnot that everybody thought was welcome and shared now become a problem. And then in the investigation, we'll find out that the supervisor was part of it and thought it was funny, and that the employee felt harassed, but there was no
Sandra Williams.
There was no proper procedure to bring it to people's attention. There was no training. There was no complaint process. So the person who may have thought the joke was funny at the time has decided that in retrospect they don't think it was funny, and they bring a complaint against the employer, and all of a sudden everything, well, yeah, that did get said, but it was just a joke, and a joke turns into liability, and we have to deal with it. So all of those pieces of training, what the expectation is for behavior in the workplace, especially as it relates to humor or attempts at humor, personal observations, compliments, racial remarks, political remarks, religious remarks, training everybody on what your expectation is. Because really, from an employer standpoint, the preference is that folks talk about work, get work done, talk about business, how to improve the business, how to deal with customers. Those should be the topics. But we're human beings, and sometimes we get off topic. And so directing your employees on what's appropriate and what's not is step one. Step two for training your supervisors is to make sure that they understand what their responsibility is as a supervisor. They're no longer a coworker. They have supervisory responsibilities, and they have to respond to and know how to react to observing or having complaints provided to them about harassing behavior that may be illegal harassment. And then you have to train your managers, and the owners have to be familiar with what to do when a complaint has been made or a report has been made about observed behavior. How do you take prompt, effective remedial steps to stop the harassment? How do you make sure people don't say things like, oh, boys will be boys, or things like that will come back and bite you? How to set up a consequence for the person who violated your expectations, and then keep checking in with the person who made the complaint to make sure that there are no other continuing problems, because that's another place employers get bit, is they think that they have solved the problem. They disciplined the person who made the sexist joke, told them not to do it again. The person who made the complaint still experiences sexual harassment, or so they say, and they don't tell the employer, and they just quit because they made a complaint and it didn't stop, so they feel like it's fruitless to go back and make another complaint, and so they end up suing you for constructive discharge, meaning they had to quit because of the work environment, and all of a sudden you're defending a lawsuit for something you thought got solved. So you've got to train your managers and supervisors to check in periodically with that employee to make sure they have no continuing concerns. So similarly, you've got to train folks on how to deal with the Americans with Disabilities Act. It's a complex act, and for you employers that have more than 50 employees, you have to comply with the Family Medical Leave Act as well. The intersection between the Family Medical Leave Act, the Americans with Disabilities Act, and workers' compensation injuries are what I call the Bermuda Triangle of employment law. It's the most complex problems you'll face. So if you have someone who is hurt on the job, their injury meets the definition of disability, and they're eligible for FMLA, you should definitely get legal help early on because there are so many places that you can trip up. But you've got to make sure that your employees know to report their injuries, that your employees know to report their serious health conditions to get FMLA started, and you've got to make sure they know about their restrictions and working with you in an interactive conversation about any accommodations or restrictions they have, or how you can maybe adjust their work to meet those restrictions. Then your supervisors and managers need to know what FMLA requires, what ADA requires, and what workers' comp requires, so that they are working with you and communicating correctly with the employee about what the restrictions are. Sometimes I'll have managers who tell people who are injured, you can't come back until you have no restrictions, until you're fully healed. That's a violation of the Americans with Disabilities Act. If they can come back with restrictions, but those restrictions can be reasonably accommodated by adjustments to their schedule or their duties or the job distribution, then an employer's got to do that. And even a small employer has to do that, unless it would be an undue hardship. And smaller employers are more likely to have accommodations serve as an undue hardship. You've got to make reasonable ones. You don't have to create jobs for people. But if you only have 15 employees and everybody has to be cross-trained and somebody can't do any lifting over 10 pounds and everybody's got to lift over 10 pounds on a frequent basis and there's no way to make everybody do the heavier lifting, that might not be a reasonable accommodation for a 15-employee company. It probably is a reasonable accommodation for a 500-employee company.
Turn right to merge onto I-80 West.
Somebody's got their nav on.
Yeah, I think somebody didn't mute. So sorry about that.
It's all right. So knowing about the Americans with Disabilities Act, knowing whether you're covered by FMLA, if you've got close to 50 employees, you need to know about FMLA. If you've got over 50, you're covered by it. You can have multiple locations, and you can add the sum total of that. So it's a complex area, and you should know whether you meet that criteria. And you should know when you have to legally provide someone with leave. And you need to do it in a non-discriminatory manner. So if you're a small employer and one of your employees wants to take 6-week leave for a religious mission trip, and you say, fine, that's okay, we'll do that. And then another employee needs to take 6 weeks leave for cancer treatment, and you say no, you could have a potential law violation there because you can't treat the religious leave differently than the disability leave. If you give 6 weeks leave, unpaid or paid, whatever, but you hold open the job for 6 weeks for the person with the cancer treatment, but you refuse to do that for the pregnant person, then you can have potential liability under the Pregnancy Discrimination Act. So handling leave, having your managers, owners, supervisors know what is required in terms of providing protected leave, even if you're not covered by the FMLA, is huge. So those are all examples of the type of training that you need to provide folks in order to have compliance with those state and federal laws. You also generally have to have an understanding of workers' compensation law, but hopefully all of you are insured, and your carrier and your carrier representative will walk you through the workers' compensation claims process if you have an injured worker. What I wouldn't want you to do is take your legal advice on the ADA or the FMLA, Americans with Disabilities Act, or the Family Medical Leave Act, from the workers' compensation carrier representative. That's not their wheelhouse, and it's really not their concern. So make sure you're getting law advice.
You have left the planned route. I will provide additional guidance after you've completed your call.
I think we have. Can everybody check and make sure they're on mute if possible?
Make sure that you are getting your legal advice from lawyers and your workers' compensation claims advice from the workers' compensation carrier. And make sure that that is meshed together. The third mistake I see sometimes is deferring personnel decisions. I see this mostly on owners and general managers. They defer the personnel decisions to HR or to a mid-level manager and say, hey, you go to some HR training, you get up to speed on this stuff and just handle it. And then when there's a termination decision, it's still being made by the owners or the general managers with the input of the HR person. But if the HR person messes up and you make a termination decision that's illegal, it's on you. There's no protection for the company if the HR person acts illegally. It's called the cat's paw doctrine. I'm not entirely sure why it's called the cat's paw doctrine, but I guess the cat is held responsible even if its paw does the bad thing. So make sure that you as owners and general managers and high-level responsible folks know just as much about HR stuff and employment laws as your HR folks and your managers that you have in charge of those areas, and make collaborative decisions and make sure that you double-check their work and are comfortable that their decision-making and recommendations are lawful. And you have to ask questions like, we're going to terminate this person because they're not FMLA eligible and they need a leave and we can't accommodate that leave and they need it for cancer treatment, but it would be too much of a hardship to hold the job open. The owner and manager's next question has to be, what have we done in other situations? Because you need to find out about that mission trip and you need to find out about that pregnancy leave and see what you're doing consistently across the board. So stay up to speed on the personnel matters and stay up to the speed on employment laws and HR laws so that you can make the final decision. The buck stops with you in the right direction. Number 4, retaliation is a separate law violation that can occur. And here's when it occurs. It occurs when an employee has taken protected action or protected activity, like made a complaint about sexual harassment, made a complaint about disability discrimination, made a complaint about racial discrimination, had an FMLA leave, had a workers' compensation injury, reported a significant safety violation of the company. If they've done any of those things and you turn around and fire them because of it, that's illegal retaliation. It's very frustrating at times to employers because if an employee quits on a bogus sexual harassment claim and goes to the NAOC and puts you through the paces at the NAOC, the last thing you want to do is rehire that person. Or if an existing employee files a complaint with the NAOC and you know it's bogus and they're still working for you and they're claiming racial discrimination and you know it didn't happen, the last thing you want is for them to continue to work for you. But the last thing you should do is fire them. What happens is we see invalid, non-meritorious discrimination complaints that go to the NAOC, but then the employer fires the person or retaliates against them, so the underlying complaint of discrimination was weak or invalid, but they end up with a strong retaliation case and damages for being fired because they were fired in response to their NAOC filing, which is federally protected activity. So anytime you're looking at a termination or a demotion or what we call adverse employment action, on your checklist needs to be, has this person ever engaged in protected activity? Workers' comp injury, FMLA leave, ADA accommodations, complaint to the NEOC, internal complaint. Have they been a witness in a complaint? Did you just learn that their child was born with profound disabilities and you didn't want them on your group insurance? That would be another example. So you've got to go through your checklist of anything they might claim is your real reason for terminating them. And retaliation needs to be on your checklist, even if you know you're not retaliating. It has nothing to do with the termination. If there was protected activity recently in the last year prior, I would recommend that your documentation on that termination be much more extensive, much more clear, so you can show a clear cause for that termination that has nothing to do with their protected activity. We are an at-will employment state. However, when you're terminating somebody in a protected class, minority status, older, female, disabled, different religion, different national origin, veteran status, marital status, etc., you need to ask yourself, what documentation do I have to show that my actual cause for termination is a legitimate, non-discriminatory reason? And you need to be prepared for the idea that the person is going to may feel like it's because of their membership in a protected class. So then the burden kind of shifts to you a little bit to be able to show this non-discriminatory reason. So you're going to want to have your memos and your write-ups and your evaluations and documentation from third parties if necessary, so that you have your evidence put together before you do that termination. And you're always going to be thinking, okay, if this goes to the NEOC and they ask me, what's the reason for the termination? What's the employee going to say, and do I have documentation to refute that? When the NEOC asks me how we've handled similar situations, what's my answer going to be? What documentation do I have to show that? It's best to think all of that through before you do an adverse employment decision, termination, or demotion. A big area is number 5. In fact, I think the rest of our areas are related to this same topic, which is wage and hour laws. There are federal wage and hour laws and state wage and hour laws, and they're generally the same in Nebraska. Small employers often think that the wage and hour laws don't apply to them because they're small, or because it's always how we've done it. I still, once a month or so, talk to an employer who says, well, we just pay everybody a salary. It's easier that way. It might be easier that way, but it's also illegal that way unless every single one of your employees meets the state and federal law exemption from overtime. And what I mean by that is only certain positions can be paid a flat salary and be exempt from receiving overtime. An employee who is not entitled to be salaried can't agree to be salaried. If their job doesn't meet the law exemptions, they have to be paid hourly and they have to be paid overtime. To be paid salary, the position has to fall within some very specific exemptions. Some apply. There's some very specific rules on domestic employees, seasonal employees, retail salespeople paid commissions, but those are specialized exemptions. The ones that apply most commonly to most employers are the executive exemption, the learned professional exemption, the administrative exemption, the teaching exemption, we're certified teachers, and the outside sales exemption, and the computer exemption. Here's how it comes up, and here's how it's a problem for you. Problems come when you are paying somebody a salary rather than by the hour, and you're not paying them overtime, and they should have been paid hourly and overtime, and you get a DOL audit, or you get a complaint from the employee, or you get a complaint from a former employee, then you can be liable to go back 2 years or 4 years and pay everybody in your organization the overtime compensation that they should have received if they had been paid properly. You can also be on the hook for attorney's fees and sanctions and interest, and it can start to be a really big number really quickly. Typically it's 2 years to go back, but if it's a willful violation, meaning you knew you weren't supposed to do it this way, but it was just easier to do it that way and nobody complained, so we just did it wrong. If it's a willful violation, it can be 4 years, and you can get tagged with some sanctions. So it's important to have this right. And here's where you really get poked hard as the employer is if you get an audit or you get a lawsuit and they go back to all of your employees for 4 years, if they've been paid salary for that whole 4 years, they probably don't have records of the hours they worked. Or you don't have really good records of the hours they worked. And suddenly, these employees remember working 60 hours a week all the time. Whether that's accurate or not, that's what their perception is. That's what they tell the Department of Labor. That's what they tell the court. And you, as the employer, don't have any records to refute that. So you're not only stuck going back paying the overtime, you're stuck paying overtime on hours that probably weren't really worked, but you don't have the hours to prove it. So you need to do a self-audit, and you need to look at all of your positions. And I say positions, not people, because it's the position, description, and duties that matter on whether the position meets one of the exemptions for being paid by salary. For example, the executive exemption are people who manage a segment of your business. And they have to regularly supervise the work of at least 2.0 FTE, 2 full-time equivalent people. It could be 4 half-time folks, but the equivalent of 2 FTEs or more. And with respect to those people, they have to have significant authority to hire or fire or make recommendations that are given particular weight. They can't just be figurehead supervisors. They've got to be real supervisors with real and meaningful input into hiring and firing and supervision and evaluation. So you might have a real small company, and you might have somebody whose title is manager of marketing. If they don't supervise 2.0 FTE, they cannot be this exemption. You could call them czar of the world. If they don't have 2.0 FTE, they won't be exempt under this particular exemption. Sometimes I run across this in mom and pop operations where you've got somebody who's been the manager of the produce department in this small grocery store, but supervises no one because it's a small operation. Well, that doesn't really meet any of the exemptions. It's not administrative work, it's not computer work, it's not outside sales work, and it's not an executive exemption. So sometimes the wage and hour laws don't make sense, and I get that. They are not intuitive. They're not even logical sometimes. So it's important to be trained on them and to do a self-audit. Another difficult area of exemption is the administrative exemption. The administrative exemption means that you are performing office work directly related to management or general business operations of the company, and you have to exercise significant discretion and independent judgment on matters of significance. So, for example, bookkeepers who run reports, pay bills, etc., are not exempt. Legal assistants, paralegals, are not exempt because they can't exercise discretion and judgment in what they do. They have to be supervised at all times by an attorney. So, for example, we have to pay our paralegals by the hour. Secretaries, office assistants, administrative assistants, those folks are not exempt under the administrative exemption. If you have a long-time administrative assistant position for like the highest ranking person in the company, it's their right-hand man or woman who really can make decisions, can sign contracts on behalf of the company, can negotiate, can evaluate, can set strategy, and really is the right-hand person, then that administrative assistant position probably has a lot of discretion and judgment and probably can be salaried. But you have to be very careful. I think that's the biggest area that people make mistakes are in their office folks and making them salaried. The professional exemption is a little clearer and easier. If you have letters behind your name that are required by the position, then you probably qualify for the learned professional. MD, JD, MSW, RN, PhD, CPA, creative professionals are, professional actors and professional singers and things like that. We don't run across that very often. Then outside sales exemption, you've got to do your work outside of the company, be on the road, visiting people. And technology has changed the role of the outside sales exemption. I don't really see an outside salesperson very often anymore because most of what used to go on the road now goes on via computer. So outside sales has to be somebody who goes out and obtains contracts and orders for your company. They're away from the facility a vast majority of the time, and they're primarily on the road getting customers and making deals for you. Then the computer exemption, I don't believe I have in my outline, but it's got to be a high-ranking network designer. It is not your computer person who is your help desk person. It's not the person that comes helps Susan Sapp with whatever problems I'm having with my computer on a given day. It is people who design your network, design your software, and are the leaders and visionary in your IT department. So, when you have salaried folks, you have to be very careful how you pay them. And when you have hourly folks, you need to be very careful how you pay them. So the first step is getting them classified in the right group. You need to calculate their regular rate of pay correctly when they're hourly. They're entitled for time and a half for any hours worked over 40 hours a week. So that means if they have vacation for 8 hours that week, that 8 hours does not count toward the 40 to kick them into overtime because it wasn't actually worked. All working time has to be paid, and this gets really tricky. If you've got hourly folks and they are working from home but not clocking in to do that, you've got a real potential problem there. You've got to train everybody. If you're doing work for the company and you're an hourly person, you've got to be clocked in. You've got to report your time to us. If you're not clocked in, you've got to report it. You cannot volunteer your time for your employer. You can't wink and look the other way knowing they work from home or are working beyond 40 hours a week. You owe them for the time worked. Even if they were supposed to get authorization for overtime and they didn't, you still have to pay that time, but you can discipline the person for working overtime without authorization, but you still have to pay it. So how many people check their work email at night? Probably a lot of us. If you're hourly, you're supposed to be paid for that. Now, there has to be some common sense here. If I spend 2 minutes looking at an email for work and responding, yeah, I'll take care of that tomorrow, is that compensable? Probably not, because basically wage and hour law says that under 7 minutes is a de minimis amount of time. So you can round your clocks, your time clocks, according to the 7-minute rule. So if 7 minutes are de minimis for time clocks, they're probably de minimis for off-the-clock work. But you can't have 5 7-minute periods in a night and not pay people. 5 7-minute periods would be 35 minutes. You got to pay folks. So they need to know what the rules and expectations are, and you need to set clear guidelines so that working time is properly compensated. The flip side is, if you're properly paid on a salary, you don't have to be compensated for hours beyond 40. That's part of the deal, is as a salaried person, you work whatever hours it takes to get the job done. So no, you don't have to pay people more for hours over 40. You can, but you may not dock them for working less than 40 unless you're taking a deduction from a legitimate PTO plan or vacation plan. You can, with respect to your salaried people, expect them to keep regular business hours. If their hours are 8 to 5 with a 1-hour lunch, then that's when they're expected to be there. If they start coming in at 8:30, you don't dock their pay, but you certainly address those late arrivals as a disciplinary matter. You can have them take 4 hours of vacation time if they take the afternoon off. You can make a deduction from your PTO or vacation bank. If they break a significant rule of the company, you can suspend them without pay for at least 1 day or more. But generally speaking, if they're salaried and they perform any work during the work week, they're supposed to be paid for that week. Hourly folks, it's more simple. If they work less than 40, you pay them for what they work. If they work more than 40, you pay them time and a half for anything over 40. But salary deductions can be messy. And you've got to be very careful on any time you're docking the pay of a salaried person, because you can lose the salaried exemption if you do it wrong, and that means you'd have to go back and pay them for all that overtime that they worked. You can require your salaried people to keep regular business hours, and you can require them to record their time. One of the biggest myths out there is salaried people often think that they don't have to be accountable for the time that they work, that they think salaried means come and go and leave, run over to the Walgreens, take a break, come back whenever you feel like it. It's not flex time. Salaried people can be required to record their time worked, and I recommend it for 2 reasons. One, if you don't have them record their time, how do you know how much time to reduce their PTO or vacation by? If you're taking vacation in 4-hour increments, how do you know if you don't know what they worked that day? Second, and perhaps more important, how do you know when a position has outgrown being a 1.0 FTE position? If you just rely on the person's perception of how much they're working, that may or may not be accurate. If you rely on your own perception, that may or may not be accurate. Time records tell you if this person is consistently working 60 hours a week, 65 hours a week, that's more than 1.0 FTE, and you need to look at hiring an additional half-time person or redistributing duties. So exercise of your management prerogative requires accurate information about time spent to do positions. So another area where people get tripped up in wage and hour is on page 5, number 3, pre- and post-shift activities. If you have people come in who are hourly and they start work 15 minutes early because they want to get a jump on things, you have to pay them for those 15 minutes. Or tell them, don't start working till your shift starts. If you allow the extra work, you have to pay for the extra work. It gets messy when people bring their breakfast to their desk and read the newspaper for half an hour before they start their shift. You have to have a clear understanding. Do not start work until 8 a.m. That's when your shift starts. Salaried people, not a problem. They can come in early. They can stay late. That's what they're expected to do. But with your hourly folks, you need clear communication on when their working time is to start, and they cannot volunteer it. If you have a nonprofit, people can volunteer their time for a nonprofit, but it has to be in a completely different capacity than their paid work. So, for example, say you have the church secretary who volunteers her time to sing in the choir on Sunday. That's fine. If you have the church secretary who volunteers her time to do registrations at the Vacation Bible School during the week, that's probably not okay, because that secretarial work is way too close to the registration work for which they're paid. So they can volunteer, but it has to be outside their paid, clearly outside their paid position. I talked about clock in and clock out time. You should pay to the minute, or you should follow the rounding rules. Paying to the minute is simpler. Rounding means you round up or down in 7-minute increments. So if the shift starts at 8 a.m. and the person clocks in at 7:55, you can round to 8 o'clock. If the person clocks in at 7:50, you have to round to 7:45. You cut that 15-minute increment in 7-minute pieces of the pie, and you either round up or you round down. That way, sometimes it's to the employee's advantage, sometimes it's to their disadvantage. So be wary of those rounding rules. Travel time is a complex area of wage and hour law, as is training time. I summarized the rules as best as I could in paragraphs 5 and 7. And then on-call time is very tricky as well. Are they engaged to wait, or are they waiting to be engaged? Engaged to wait, you have to pay them. Waiting to be engaged, you don't have to pay them. So you look at, are they required to stay on premises? Are they called frequently? Are they free to go anywhere they want to or engage in personal activities without restrictions? Training time, if you are sending somebody to training and it's during their regular working hours and it's not voluntary and you're sending them to training so they do their job better, you've got to pay them hourly for that training time. So the flip side is you don't have to pay them if they go outside their working hours. If they decide to do it voluntarily, they don't do any work for your company while they're there, and it's not directly related to their job. I'm not sure what the value is of that kind of training, but that's the time when you don't have to pay them. Otherwise, you do. If they're salaried, it's no problem because it's occurring as part of their expectations under their salary. So the employer takeaways are: do a self-audit of your wage and hour compliance. Do it before Department of Labor gets there. Do it before you get a lawsuit. Do it before you have a willful violation. Put your job descriptions into piles that are clearly exempt and can clearly be salaried, and jobs that clearly need to be hourly. And the ones that are left are your gray area positions that you should have legal review on. You also need to update your job descriptions. If you get an audit and DOL comes in, they're going to interview your employees and ask your employees, what do you actually do in this position? And if the job description is 15 years old and doesn't accurately reflect what they do, DOL will go with what the employee says they do. So update them, make sure they're accurate, and make sure that you use the right verbs and words to meet the particular exemption that applies. If it's administrative, make sure you talk about their significant discretion and independent judgment, and then list the topics on which they exercise discretion and independent judgment. Have your exempt employees keep track of hours. And make sure that everyone is trained properly on clock in and clock out, working time, and how they're paid so that you're in compliance. So with that, I'd be happy to take some questions.
Hi, have a question. This is Sierra Forrest. And I was just wondering, on legal hiring procedures, where can we find all of the requirements for what needs to be stated specifically in job descriptions for when we're hiring for new positions?
Well, it's going to be fact dependent. So there's no real template that I'm aware of for particular job descriptions, but you need to have, depending on the type of job, you need to have clear sections on essential job functions, physical requirements, training and education, experience required, physical demands, how much percentage sitting, standing, that kind of stuff. So you've got to have as much detail as possible, but in terms of legal requirements, I'm not aware of a resource that really gives you a template.
Okay. Thank you.
This is Greg Christensen. I'm just wondering, you referenced particular items or numbered items in a document. Was that something that we should have received in advance, or was that just your outline that you were using during your presentation?
Greg, if you didn't receive that, I'll email it to you quick.
Oh, okay. I tried to check back through emails and didn't see it.
Yep, I'll make sure you got it.
All right, thanks.
Please let me know if you don't receive this within the next 5 minutes.
Okay, great. Thanks.
Thanks.
There was a question that somebody had submitted ahead of time on contract employees. When can you have an employee be treated as an independent contractor? It's very fact dependent, and it's an IRS rule in particular, and it has a lot of component parts, like they set their own hours, they use their own equipment, you don't dictate what they do when, they tell you what they're going to do, you hire them per job. So it really comes down to primarily the locus of control. So it's hard to give you a pat answer on that. But for example, if I have somebody come paint my house, I tell them what color to use, but beyond that, I don't have much input. They come when they feel like it, they paint it in the order that they want to paint it, they tell me what they're going to charge, and I'm happy with it. That's an independent contractor. If you have somebody coming in and performing work that could be performed by an employee, and maybe has been in the past or currently is, and you tell them what hours to work, and they use your equipment, and they're on your premises, and you evaluate their work, that's an employee. So it's fact dependent on what lies in between those, but it's a dangerous proposition to have an independent contract and be wrong, because that means you didn't pay in FICA and Social Security for these people. You have tax liability. They can have liability, so you want to get it right. There was a question on, are there state or federal mandatory numbers for personal days off for employees? The answer is no, but do understand that anything labeled as vacation or personal time off is a cash accrued benefit to your employees and must be paid out at the time of termination. If it's sick leave and it's properly labeled as sick leave, that does not have to be paid out at termination. So what I mean is, if I get terminated, whether I'm fired or I quit, and I'm sitting on 40 days of paid time off that's accrued that I would be entitled to take, but I hadn't taken before my termination, I get paid the cash value of that at the time of termination, and it's unlawful not to. You can cap accrual for people. It doesn't mean you have to sit perpetually on a contingent liability of thousands of dollars of paid time off. You can tell people the maximum accrual for your paid time off or vacation is 20 days or whatever you decide the max accrual is. If you're sitting on 20, you don't accrue anymore until you use some and bring it down below 20, at which point you can start accruing again. Your policy needs to be very clearly written to have a cap on accrual, a maximum accrual.
May I ask a question? May I ask a question about that?
Sure.
Are you required to provide a employee with vacation pay, holiday pay, or any other non-working pay?
No.
Okay.
But if you do, then it has cash value. The vacation and the PTO have cash value.
Okay.
They can't be taken away once it's accrued.
Right. Okay.
Then somebody said, how do I go about finding and keeping qualified employees? If you know the answer to that, then you win a prize. Yeah, that's the toughest challenge I think most employers are having. You know, what I've read is that generally speaking in our society, 3% of people are unemployable. Well, if you have a 3% unemployment rate, then you're fishing in a difficult employment pool. So I don't have a real good answer for that. You know, competitive wages, wellness programs, things that attract quality people and quality benefits are going to be your best way to get and keep employees.
I have a question in regards to hourly employees.
Yes.
If they, the business is referenced to like an elder care, so the employees will visit different sites or different houses. Do they get paid for travel time and or?
Yes.
And if they don't, and for gas and all that, because I'm asking because currently they clock out after each one, but there's that 15 minutes to get from one place to the next.
Oh, they need to be paid.
And what about like a meet and greet? Like if you go to meet for like for an hour, but you're not physically working, would that be considered?
If it's required, yep.
Okay.
Anything the employer requires them to do is working time. Any travel? Go ahead.
Sorry. And would travel be? It'd probably be hourly plus mileage then, or?
Typically, that's what we see is hourly. It has to be hourly, and then
okay.
Typically, to be competitive, you're going to need to pay that mileage as well.
Okay.
But definitely, wage and hour laws are clear that travel from one work site to the next in the course of the workday is compensable.
Okay.
Your commute to and from work is not paid work time, except if I send you out to a remote site that you don't normally work at, then the travel time from your normal work site to the temporary work site is working time.
But with travel time, since it's not your stationary place, so it's the travel time from your house to said person's house, would be considered payable then?
Well, if you're going around from house to house, and you don't come to a central work site, then from the time that you take off, it gets complicated because if you live out of town, then you wouldn't count the person's commute from their hometown to the town in which they work.
So it actually most likely be after the first stop, basically from that point until your last stop.
Yes, that would be typical.
Okay, thank you.
So are you required to pay both the hourly wage for the travel time and the mileage, or just one or the other?
No, you're always required to pay the hourly time. The mileage, to be a competitive employer, you're probably going to need to pay that too, but the wage and hour law does not say you have to pay that mileage. You've got to pay the hourly work time. But the vast majority of employers pay that mileage. Well, I think we're out of time here. Thank you very much for your questions and your attention. I appreciate it.
Yeah, thank you, Susan, for presenting. So, and I will be sending out a follow-up email if any of you have additional questions. We'll have some additional information in there. We do invite you to join us for our next T3 training, which will be Tom Luke presenting on Facebook Business Basics. Again, if you want to register for that, I will have a link in the follow-up email, and it's available on grownebraska.org/training. So thank you again to our sponsor, the Nebraska Enterprise Fund, and to Susan for presenting. I hope everyone has a great day.
Thank you. You too.
Thank you. Heidi.